you so much to Makhdoom Saab and to Faisal Naqvi for those quite extraordinary and generous words of introduction. And first things first, it is an extraordinary privilege to have been invited to the Centre to give this inaugural lecture. I've known Barrister Majid for more than 20 years, from a period when we were both really quite young, and I saw this brilliant young international lawyer from Pakistan, and it was so plain that she was set to go as far as she wanted to in the world of international law. As I was looking through some past emails in preparation for this lecture, I found this one, which was a response to something Nusrat had very generously said to me sometime back in 2001 in relation to a case I'd done very well. So I responded to say, well, that is very kind, but I am looking forward to the time, 2 or 3 decades from now, when Toby will be the president of the world of international arbitration, you will be president of the International Court of Justice, and I, meanwhile, will aspire to being president of the South Oxfordshire Rambling Association. Well, as things have turned out, Barrister Majid's sense of public duty has come to a slightly more domestic focus than I anticipated, whilst my application for the Ramblers Association was rejected when they found out that I'd spent my teenage years engaged in cross-country motorcycle riding. But what a loss for the wider international law community, and what again I would say for Pakistan and for this wonderful centre. First things first, and as some of you in this very erudite audience will know, that is one of the greatest poems by W.H. Auden. And when in March 1957 Auden concluded this poem with the words, "Thousands have lived without love, not one without water," he deftly identified that all human aspirations and desires are as nothing compared to the basic need for water. In the same year, in another continent, the negotiations for what was to become the Indus Waters Treaty were reaching a critical phase. In May 1957, heads of agreement were sent by letter from the World Bank. And in these heads of agreement, it was proposed that the entire flow of the western rivers would be dedicated to Pakistan, that is the Indus, the Chenab and the Jhelum, to Pakistan's exclusive use and benefit, while the eastern rivers, the 3 eastern rivers, would go to India. And although this was to be joint use principally through division, the 2 states were slowly coming to a consensus on a point almost as fundamental as Auden's, that the enduring utilization of a common water resource requires agreement and cooperation and recognition of competing needs and interests, ideally hardwired into a treaty with a binding dispute settlement mechanism to deal with all the disputes that will inevitably arise. And this is what the 2 states achieved just a few years later in September 1960, when they completed the Indus Waters Treaty, which still represents, even though some point to its imperfections, an almost unparalleled achievement in the world of international watercourse law. And also in 1957, for good measure, not only did Pakistan win its first ever test match against Australia by some 9 wickets, but also the landmark award was handed down in the Laclanu case between Spain and France, which is the foundational case in terms of establishing the basic customary international law principles in terms of equitable harm and equitable utilization and no significant harm to downstream states. This was to remain the most important arbitral award in this field of international watercourse law until 2013, when the partial award was handed down in the Kishinganga arbitration. 3 questions then that I wish to address today. First, when Pakistan has the benefit of the Indus Waters Treaty and the long-standing Permanent Indus Commission, why does my lecture title speak of crisis, other than a way of seeking to entice people here on a Friday evening when they'd much rather be somewhere else? Second, how do the issues that Pakistan faces fit within the broader scheme of how other states have been addressing the critical need for a cooperative approach to using a shared watercourse, in particular in regions where relations between riparian states are not so good? Third, what are the tools now available to Pakistan to enable it to protect its vital water supplies, bearing in mind that there is now a history of dispute settlement under the Indus Waters Treaty? And there is an obvious question as to how the treaty looks after almost 60 years, and can we still look at it as being fit for purpose? A crisis. So is there a crisis? Unfortunately, I fear there is. Most obviously, there is the crisis of climate change that is affecting us all, but is particularly acute when it comes to Pakistan. As those in the room will know far better than I, Pakistan is one of the countries of the world with extremely high water stress. That is, where businesses, farms and communities are particularly vulnerable to water scarcity because of high water demand and limited availability. You can all see that on the screen there, with Pakistan in exactly the wrong shade of red. To get a flavour, total dam storage to Pakistan represents only 30 days of average demand. You compare that to India, it has 220 days of average demand storage. Compare it to Egypt, and it has 1,000 days. And as follows from the WAPTA graph, which is about to pop up onto your screens, which is taken from the IMF's 2015 report on global water challenges, the equation between supply and demand has changed radically since 1960, when the Indus Waters Treaty was concluded, due almost exclusively to the rise in population. And yet, of course, the basic dynamics of Pakistan's water supply haven't changed, and they can't change because the basic dynamics are one of low participation and very, very high reliance on the waters that come from the Indus Waters system. Now that system is of course fed chiefly by snow and glacier melt from the Himalayas. But you may have picked up a couple of months ago an incredibly detailed analysis was produced by the Hindu Kush Himalaya assessment, a truly impressive piece of work to which hundreds of scientists participated. And that showed that even if we managed to keep to the 1.5 degree rise in global temperature, 1/3 of the glaciers will melt by the year 2100. And in the sadder and to me rather more likely event that we don't keep to that 1.5 degree rise and it goes higher, then 2/3 of the glaciers will be gone. And that's an awful thought. It's awful from all sorts of viewpoints, but it's particularly bad for Pakistan. For some countries, the melting of the glaciers will see or be balanced out by some increase in precipitation, but not so for Pakistan. As the Himalaya Assessment Report records, an exception to the benefit of increased precipitation is the Indus Basin, because in the Indus River system, the main contribution is from snow and ice melt, and to a much lesser degree from rainfall. So it is a very troubling picture, and one that is aggravated, of course, by Pakistan's position as a downstream state. In the course of the 2012 hearings in the Kishinganga arbitration, Pakistan made the point that unless the technical restrictions in the Indus Waters Treaty were stringently adhered to, India would be able to use the dams that it was permitted to construct in the upstream reaches as run-of-river plants as a sort of tap to control the flow that came down across the borders into India. And this submission had real force because Pakistan had experience from 1948 of, in effect, a tap being closed by the state of East Punjab when certain canals were diverted and flows into Pakistan were halted. And to use the words of John Briscoe, who is a former senior water advisor for the World Bank, India's current dam construction project or program is an existential issue for Pakistan. He explained that if India is able to build upstream dams with large storage capacity, as was the case with the Baglahar plant, this will remove Pakistan's protection against upstream manipulation of flows in India. Writing in 2010, he continued, if Baglahar was the only dam being built by India on the Chenab and Jhelum, this would be a limited problem. But following Baglahar is a veritable caravan of Indian projects: Kishinganga, Sawalkot, Fakuldal, Bursa, Delhusta, Jipsa. So, Makhdoom Saab will recall how William Wordsworth wrote, "The river glideth at his own sweet will." Well, I fear not, so far as concerns the upper reaches of the Chenab, or at least certainly not if Indian hydro engineers have their way. How does Briscoe continue? And I think it's worth having it up on the screen for you to read it, because it's such a helpful explanation. The cumulative live storage will be large, giving India an unquestioned capacity to have major impact on the timing of flows into Pakistan. Using Baglahar as a reference, simple back-of-the-envelope calculations suggest that once it is constructed, all of the planned hydropower plants on the Chenab, India will have an ability to effect major damage to Pakistan. And he explains it further. He explains how the damage can arise. First, in terms of the moment when the dam is filled up, the reservoir is filled up by the dam, clearly affecting an interruption in the flows down to Pakistan, and he suggests that had a material adverse impact so far as concerns the filling of the Baglahar. But second, the more, I think, overall worrying impact in terms of what he calls a permanent threat, which would be the consequence of substantial cumulative live storage, which could store about 1 month's worth of low season flow on the Chenab. If, God forbid, India so chose, it could use this cumulative live storage to impose major reductions on water availability in Pakistan during the critical planting season. So Pakistan has concerns as to the control that is potentially within India's hands, and that control is well grounded. It's grounded in history in terms of the events in 1948, and it is also grounded in terms of the potential impacts of upstream dams. Now, happily, the Kishinganga Court of Arbitration recognized in its 2013 award that the 1960 treaty reflected, and I quote, a careful balance between the parties' respective negotiating positions, allowing India hydroelectric use of the waters of the western rivers while protecting Pakistan against the possibility of water storage on the upstream reaches of those rivers, having an unduly disruptive effect on the flow of water to Pakistan. So this is the court coming to precisely the opposite conclusion that the neutral expert reached in the Baglahar case. Of course, the Court of Arbitration couldn't act as a court of appeal. It couldn't overturn expressly what had been done by the neutral expert so far as concerns Baglahar, but it could address the issue far more broadly with respect to all other projects that would be built on the western rivers, including, of course, the Kishon-Ganga. So, the Court of Arbitration made an order to this effect, restricting a practice which is called as banal or difficult or technical as drawdown flushing, which in effect means you lower down the reservoir and then you flush out all the sediment and then you fill it back up again. But that sort of interruption in the flow, if you think about it, what it means potentially is a cascade of water coming down into Pakistan, followed by the closing of the floodgates, the dam gates, and then however long it takes to fill the reservoir up again. So it's a very potentially serious impact into the flows of the western rivers. So that was a very significant result indeed for Pakistan. But, and we've seen this as recently as the events of February of this year, speedily, very speedily, water can become enmeshed with the political tensions that exist at times with India. Now, of course, India's announcement that water supply would be restricted concerned the eastern rivers, and you'll recall the eastern rivers are rivers that are essentially dedicated to the benefit of India under Article 2 of the Indus Waters Treaty. But for me, the announcement still sat rather uneasily with what India's representatives had been saying during the Kishon-Ganga hearings, which was to the effect that the 1948 closure of canals was entirely an isolated incident, and that there was no cause for thinking such an incident could happen again in light of 50 years of interference-free practice. I move on now to the second of my three questions, and it's to be emphasized to their extreme credit. Even at times of war, Pakistan and India have known how to protect and to keep functioning the water regime of the Indus Waters Treaty, to keep performance going under the treaty, to keep the Commission functioning. But if you look elsewhere around the globe, other states have not been so successful. An obvious example is the River Jordan, where attempts to establish a water regime between the riparian states were taking place at roughly the same time as the Indus Waters Treaty was being negotiated in the 1950s. And what one saw is a US ambassador coming over to Jordan and to Israel, trying to effect a compromise between these two states and the upstream states of Lebanon and Syria as to the sharing of the waters of the Jordan. And you can see, rather curiously, the US was being inspired by the success of the Marshall Plan in Western Europe, and it was trying to effect something similar over in the Middle East. To an extent, this was successful. At least the technical people were able to agree on a form of water allocation. 35 million cubic meters was to go to Lebanon, 132 million was to go to Syria, 720 to Jordan, and the rest, which was around 660 cumecs, was to go to Israel. But unfortunately, the Johnston Plan never made it into a treaty that was ratified. And what one saw is water becoming increasingly part of a geopolitical conflict, because what the parties were not able to do, in the way that Pakistan and India had done so sensibly with the Indus waters, rivers, they isolated it from the dispute in Kashmir. The riparian states to the River Jordan were not able to do that. And so one saw specific strategic actions as part of the broader geopolitical conflict, targeting canals built with respect to the Jordan River, canals that had been built in part to implement the plans that Johnston had. Indeed, I mean, Israel has struck out in the past, in the early 50s and 60s, canals that had been funded by US monies, and likewise certain of the canals built by Syria. All is about the control of the water in the upstream reaches, of course. And this was one of the factors leading to the 6 Days War in 1967. Now, fortunately, since then, of course, Jordan and Israel were able to agree their peace treaty in 1994. And that does deal with water, but it deals with water in a rather an unsatisfactory way, because it's more about establishing a program for the delimitation of the future uses of water, as opposed to really finally solving the difficulties. And although there is an allocation or a degree of allocation of water supplies, it's one that is less favourable to Jordan than was the case with the Johnston Plan. And these are the words of the distinguished commentator in this field, Salman Salman, who some of you will know, and who was also a former advisor of the World Bank. He describes matters as follows: as drought and climate change are engulfing the region, the Jordan River is carrying less water every year, and thus the share of Jordan is likely to decrease. With the Israeli occupation of the West Bank and the Golan Heights of Syria, and control of the major sources of the Jordan River, and the inequitable deal that Jordan agreed to under its peace treaty with Israel, the Johnston Plan has clearly lost its vitality and relevance. So in short, the downstream users have been left with rather little water, little control, and as we all know, the Dead Sea, which is the terminus point in the Jordan River, is shrinking and is notoriously under threat. So what about the longest river in the world? This is the Nile, of course. And here, historically, the downstream users, Sudan and in particular Egypt, have had by far the most extensive uses. And they have sought to protect those uses in treaties dated 1902 and 1929, which effectively subject upstream use to downstream consent. What a wonderful sort of treaty that is for the downstream states. And you slightly wonder, now how did the downstream states get the upstream states to agree? And of course, when one looks at it, the answer is very simple. This is all part of the colonial era. So you had a period where Great Britain was effectively negotiating both sides of the treaty, a rather unattractive position. And unsurprisingly, when the upstream states became independent, they refused to be bound by these two treaties, and they likewise refused to be bound by the 1959 agreement between Egypt and Sudan for the full utilization of the Nile waters. It's rather an odd idea, isn't it, for two downstream states to agree between themselves on the full utilization of the waters, to allocate to themselves very high figures in terms of what would be coming down the river, as if somehow the downstream state could freeze the upstream uses. Since those days, things have improved markedly, at least in terms of the foundation of the Nile Basin Initiative, and so the 11 Nile Basin states do now interact, and the aim of the Nile Basin Initiative is to share out, to use the Nile resource in a sustainable and equitable way for all its users. So far, so good. And a comprehensive framework agreement has even been negotiated. And that's an agreement which has the features of a modern watercourses agreement. It brings in some of the now almost standard protections that we've seen crystallized from customary international law into the 1997 UN Convention on International Watercourses, principles that derive from the Lake Lanu case on protection of the downstream state from significant harm, the principle of equitable utilization, and the like. So that all sounds rather good. The only difficulty is that only 3 states have ratified the Cooperation Framework Agreement, and Egypt and Sudan remain opposed, it appears because they do not regard the agreement as sufficiently protecting their existing uses. So there's a standoff, and it's a standoff that helps nobody. And it's one that is being put under particular pressure at the moment because of Ethiopia's decision to go ahead in the year 2011 with construction of the Grand Ethiopian Renaissance Dam, about 20 miles upstream from the border with Sudan. And indeed, this is a very grand dam. It pops up on the screen now, a thing of beauty? I think not. But there it is. And this is going to be the largest dam in the African subcontinent. It's going to produce in the top 10 of dams in the world in terms of hydroelectric power. It's got an installed capacity of 6,000 megawatts, which, if you think about it in terms that are more readily appreciable perhaps to this audience, that is some 20 Kishinganga plants. It's a spectacular endeavour. And it's a spectacular endeavour which, perhaps unsurprisingly, has been met by strong protest, initially by Sudan, but particularly by Egypt, which of course is concerned with threats to its downstream uses. The parties were able to agree on an expert independent panel, at least to identify the downstream impacts. So far, so good. But here we are in a world where there is no treaty regime. And so Ethiopia elected to divert the waters of the Nile to continue works on the dam without waiting for the results of all the expert studies. So a fait accompli was suddenly taking place on the ground, with the upstream state flexing its muscles. Slowly, Egypt and Sudan have had to come to look at the Grand Dam as reality, and they've agreed a declaration of principles in 2015, which includes some of the modern principles of customary international law as protections. Again, no significant harm, equitable utilization, and the like. But the tensions remain, very much so, including in terms of the filling of this dam, which takes, even according to the barest technical specifications, 3 years, which gives you an idea of the scale of the planned reservoir. Egypt says we need 10 years, because if you don't take 10 years, then the impacts to our existing uses are far too great. So the problems that Pakistan faces as a downstream state are very far from unique. And so one asks, what protection does international law accord to vulnerable downstream states like Egypt, like Pakistan, leaving just to one side for the moment specific treaty regimes like the Indus Waters Treaty? The obvious reference point here is the 1997 UN Watercourses Convention, which I mentioned a moment ago, which entered into force in August 2014. Pakistan's not a party, and nor are any of the Indus Waters states, but it's widely recognized as reflecting customary international law so far as concerns the key principles in terms of the Article 5 obligation to use watercourses in a reasonable and equitable manner, the Article 7 obligation to take all appropriate measures to prevent the causing of significant harm to other watercourse states, the Article 8 obligation of cooperation, and the Article 12 obligations of notification and environmental impact assessment where measures are planned that may have a significant impact on other watercourse states. And in terms of this coming and being recognized as customary international law, we saw just a few months after the treaty was signed in 1997, reference being made to it in the Gabchikova-Najimarosh case that Faisal Naqvi mentioned a moment ago, and the key protections have since been referred to in the big international water cases before the ICJ, the Pulp Mills case, and the more recent case of the road between Costa Rica and Nicaragua. So it might be asked, given that Pakistan is protected by the prohibition of significant harm as a matter of customary international law, and also has protections with respect to the environment and with respect to a right to equitable utilization, does it still benefit so much from the Indus Waters Treaty, which of course does not contain these express standards? And here there are 4 points that I'd like to make. First, the obligation to prevent harm, as reflected in Article 7.1 of the 1997 Convention, is an obligation of conduct, not of result. The state has to take all appropriate measures. So it's a form of enhanced due diligence obligation. It's not an absolute knockout rule. And one asks the question, well, how much protection does that really afford to the downstream state? Second, there's a tension in the 1997 Convention, just as there is in customary international law, between the principle of equitable and reasonable utilization on the one hand and the principle of no significant harm on the other. Now, if I'm an upstream state, I'm going to say I like the principle of equitable use, just as, for example, Ethiopia would in the case of its dam on the Nile. It would say, I have a right to a perfect equality in the use of the waters, and that is something that should be reflected in my upstream use of the waters, instead of always protecting the downstream use that Egypt has had the benefit of for centuries, or indeed for millennia. But the downstream state, by contrast, is going to say, well, look, upstream, this upstream development is causing significant harm to me, and the significant harm rule should be seen as the predominant rule. And that's a genuine tension that is not resolved within the 1997 Convention. It's not resolved in customary international law. And it's interesting to note that the ILC special rapporteur who was behind the 1997, Professor Stephen McCaffrey, who some of you will know, was one of the counsel for India many years down the line in the Kishan-Ganga arbitration. His view in his important book on international water courses is that it is the principle of reasonable and equitable utilization that may be the dominant one, so something of slight concern for a downstream state. And by contrast to that difficult issue, the Indus Waters Treaty offers far greater certainty as to what is and is not permitted, allocating the respective rights and responsibilities of the upstream and downstream states through detailed provisions as to who can do what and when, as opposed to through general principle. A footnote to bear in mind here is that Article 6 of the 1997 Convention contains a list of factors as to what a court or tribunal should be looking at in order to gauge whether usage is reasonable or equitable. And it's interesting to see that in the ILC working group, India was very much engaged and saying one of these factors should be the contribution of the state to the water course. And you can think, well, India must have had in mind its contribution so far as concerns being the upstream state, or one of the upstream states in the Indus water system, and its contribution so far as concerns the Ganges flowing into Bangladesh, where essentially 90 or 95% of the Ganges River is within Indian territory. Certainly in the Kishan-Ganga arbitration, India was keen to present itself as making a very large contribution to the waters of the Indus system, but in fact only getting a very hard bargain sort of an allocation, because India was saying, well, hang on a sec, look at these water flows and you'll see that Pakistan is getting more than 80% and we're getting less than 20%. So in essence, the subtext was, when it comes to interpreting and applying the treaty today, you should be giving us the benefit of the doubt. Third point, although the Indus Waters Treaty doesn't contain a rule on no significant harm, it does fall to be interpreted taking into account customary international law. So it's not stuck in the early 1960s, as you might be thinking. In the Kishan-Ganga arbitration, the court held that India had an obligation to leave some significant flows in the old riverbed, and that derived from the treaty interpreted and applied consistent with customary international law, in particular the duty to prevent or at least to mitigate significant harm to the environment that would result when the upstream states pursue large-scale construction activities. Fourth point, one of the key features of the Indus Waters Treaty, and it is a rare and valuable treasure so far as concerns discrete watercourse treaties, is the dispute settlement mechanism. For those of us in the room who've looked at Article 9, we may just look and think, headache. We shouldn't think headache, we should think this is a wonderful thing, because what it does is to provide not only a treaty, but a treaty with teeth, so that Pakistan, likewise India of course, can enforce rights under the treaty, either by going to a neutral expert so far as concerns technical issues, or by going to a court of arbitration so far as concerns legal issues. It's an incredibly important protection. Also, the Court of Arbitration has the power to order interim measures. Another very, very valuable tool, particularly if you look upstream and you see a project taking shape. Think by comparison, Egypt, when it looked upstream, it saw the wonderful grand Ethiopian Renaissance Dam. There was no tribunal that it could turn to for its claims, no tribunal to seek interim measures, allowing for construction to be halted, at least while further impact studies were taken. And the same could be said for Jordan when it comes to disputes with Israel over water, or Bangladesh, with, so far as concerns disputes with India over the Ganges, or the downstream states so far as concerns the 1995 Mekong River Agreement, and so on. And the landmark judgment of the International Court of Justice in the Gabčíkovo-Nagymaros case only came into being because, in essence, of the goodwill of Slovakia, that was willing to enter into a special agreement with Hungary in order to bring the dispute before the court. Otherwise, no case. So the Indus Waters Treaty offers far more and more tangible protection to Pakistan than customary international law. But, of course, one asks, how is it now going to fare in the light of what Professor Briscoe has referred to as this veritable caravan of projects, which you can see up on the screen in this slightly messy looking map. But all you need to take from that map is that so far as concerns the upper reaches of the western rivers, the dots mean dams, either actual or anticipated. And of course, this question has to be asked in light of the fact that we do now already have certain determinations having been made. We have seen Pakistan refer a difference to the neutral expert in the Baglahar case, and we have seen Pakistan refer the Kishinganga dispute to a court of arbitration. And it could be said, and I think I was interested to hear Faisal Naqvi refer to the issue of the press, it could be said, if you're looking at this in very crude terms, well, hang on a sec, Baglahar was finished, Kishinganga is now up and running. How good is this treaty after all? So let me make some points as to that. And first is a general point to make, which seems to be rarely understood anywhere in the world, which is that neutral experts and arbitrators are human beings. And if they're approached with a difference or a dispute where a dam is half or 3/4 built, or where a state has spent $200 or $300 million already, and they're being asked by another state to bring that project to a halt, or to effect significant amendments to the project design, then they will find that very difficult, even if the downstream states' arguments are good in law. So it's vital for all downstream states, including Pakistan, to identify their disputes at an early opportunity and to bring those disputes before the appropriate forum at the earliest opportunity and before the concrete pours into the riverbed. And that, of course, isn't as straightforward as it might appear, because upstream states are extremely good at drawing out disputes into negotiations or trying to get the matters lost in whatever joint commission may have been established by agreement of the states. In the Baglahar case, by the time it came to a site visit, what the neutral experts saw was a large lump of concrete next to the Chenab. And while we as lawyers saw a rather unseemly lump that could be threatening water supply, threatening the environment, he saw the beginnings of a beautiful dam. And he saw this as a well-designed dam, designed to meet a problem of sedimentation, which India emphasized again and again. And he subsequently determined and decided exactly like an engineer, finding it very difficult to recognize the strength of the legal arguments that were being put before him. In the Kishinganga arbitration, the Court of Arbitration was equally very sensitive indeed to the issue of facts being put on the ground which would impact on any final decision it would want to make in Pakistan's favour. And at a provisional measures hearing in 2011, it was willing to accept the argument that in practical terms, what it could later decide could be impacted so far as concerns facts established on the ground by India in the meanwhile, which is a very important decision because it's going beyond the established precedents in cases before the International Court of Justice, like the Great Belt case. And it said, "It is not difficult to envisage a situation where the construction of permanent works leading to the erection of a dam on the riverbed runs the risk of a prejudicial fait accompli, as the existence of such works would inevitably need to be taken into account in any consideration of remedies should a breach of the treaty be determined to have occurred." So a very important ruling, very important and successful for Pakistan, because the Court of Arbitration was willing to halt the dam works on the riverbed. So a nice success. But it's also a warning so far as concerns all future cases, because the court is saying very candidly, our final decision can be shaped by what the situation is on the ground. And of course one sees that in the final award, because before the case got to the Court of Arbitration, sure, the dam had not yet been constructed in the Kishinganga, but India had already constructed or started constructing this massive diversion channel, and it was very keen to take the Court of Arbitration there. Look at our wonderful tunnel, look at our wonderful brand new tunnelling machine, although not quite brand new because it's been working a lot. You wouldn't want us to consign these hundreds of millions of dollars to the dustbin, would you? And I think you can see that in the court's final award. Now I just want to say a word or two about that final award, because I was very interested to note in Professor McCaffrey's 2019 edition of International Water Courses, he picks up on a commentator who describes the award as saying, well, India of Kishinganga, but it lost the war. And one thinks, well, is that accurate as a description? So first of all, so far as concerns the battle, is that correct? And of course, it is true in the one sense that the tribunal didn't stop the project going ahead altogether, but it made very significant rulings in Pakistan's favour, particularly so far as concerns leaving significant flow in the old riverbed, which flows down into Pakistan and becomes the River Neelam. More than that, in an exceptional order, it left the door open to Pakistan, admittedly also to India as well, by saying in 7 years you can effectively come back, seek reconsideration of the minimum flow through the Permanent Indus Commission and the mechanisms of the treaty. once you've had 7 years of seeing how the environment is impacted, how the finances of the Neelam-Jhelum hydroelectric plant are altered. So that leaves a very significant and interesting opportunity for Pakistan, but also for India, to come back when the 7-year period expires in just 18 months' time. And one thinks, well, here's the clock is ticking. And although the court found that the Neelam-Jhelum hydroelectric plant, which was then still under construction, didn't qualify as a pre-existing use that would in effect prevent the transfer of water upstream at Kishinganga, which of course is what India was looking for, the court was still willing and wanting to afford a measure of protection to Pakistan in terms of environmental flows, but it was also looking very carefully at impacts downstream to the Neelam-Jhelum plant. And it said in terms, it was looking to secure a balanced approach. And it said India's right to divert water for the operation of the Kishinganga plant is tempered by Pakistan's rights to hydroelectric and agricultural uses of the waters of the western rivers. And that's more than just a reiteration of the relevant treaty provision. So Pakistan has ended up in a much, much better position than it would have done had it not fought the case. And all credit is due to the government, to the secretary, to the Pakistan commissioner, and the Attorney General's office for pushing the case forward, and indeed for pulling together a team of both local, I would emphasize local, and international experts, both legal and non-legal, to fight the case. Although, indeed, as Professor Naqvi mentioned earlier, the international law experts that Pakistan was sensible enough to instruct were the two preeminent practitioners in international law, Professor now Judge Crawford and Professor Vaughan Lowe. And I hope that Pakistan's representatives will have enjoyed noting how India started that hearing in supreme confidence. And then by day 10, some of us were noting, well, it's very curious how one of the Indian senior representatives has developed a noticeable nervous tick, because this was a very close-run thing for India. And I do think that if this case had been brought, or could have been brought a bit earlier, before the works on the diversion canal tunnel had been advanced by India, then the outcome might have been rather different. And indeed, the Court of Arbitration said very clearly, or set down an indication to the parties that should similar issues arise in the future, the treaty parties were there to be engaged before construction commences. That so far as concerns losing the battle. As to losing the war, I think that is pretty plain. And one can gauge India's enthusiasm for the award by India submitting out of the blocks like that a request for interpretation and clarification. And we as lawyers, we see these from time to time. And this was the sort of request for clarification and interpretation which says, you court, you have said that drawdown flushing is not allowed. Now, can it be clarified that you left this not in here by mistake? And in fact, what you mean is that it is allowed. And the Court of Arbitration saw straight through this, gave the request short shrift, stating in plain terms that it is for India to secure appropriate locations and to draw appropriate designs for its run of river plants, bearing in mind that the Indus Waters Treaty has foreclosed the depletion of dead storage for drawdown flushing, and that this prohibition is based on constraints that are part of the treaty's essential bargain. So, although the Court of Arbitration had no power to set aside the incorrect answer that had been given in the Baglahar case, its ruling applies so far as concerns all other Indian plants, and this offers very significant protection to Pakistan. I'm aware, I should say, that there has been some controversy as to what has happened since in the Kishanganga dispute, with Pakistan wishing to see another court of arbitration and India wishing to see matters going off a neutral expert. And there's been something of a standoff, and this has led to the World Bank putting matters into a holding pattern. I don't know the details at all, but I do proceed on the safe assumption that whatever tactical decisions Pakistan makes, it makes these following very careful thought and knowing well that the vitality of the Indus Waters Treaty, including its dispute settlement provisions, is essential to Pakistan's water security going forward. For as we edge towards the third decade of the 21st century, which is a rather frightening thought, Pakistan for sure faces many critical issues in terms of securing water for its growing population, but at least it has the benefit of functioning and enforceable protection under a tailor-made and well-balanced watercourse treaty, a legal protection that many, many other downstream states would yearn for. And with this important legal tool and constant vigilance also, the next generation of Pakistan's international lawyers will, I hope, have an ear for poetry and an eye that allows them to say, as to each of the western rivers, I see what was and is and will abide. Still glides the stream, and shall forever glide. The form remains, the functions never die. Thank you very much indeed.